The committee, and we have the pleasure today and tomorrow morning of considering the initial report of the Macao Special Autonomous Region, and to music outside, and to introduce the delegation. It's my great pleasure, again, 2 weeks running, to call on the permanent representative of the People's Republic of China, Ambassador Liu Jianmin, to address us. You have the floor, sir.
Mr. Chairman, it's a great pleasure for me to attend today's meeting on behalf of the Chinese government. As you are aware, as of the 20th December 1999, the government of the People's Republic of China has restored its sovereignty over Macau and has established the Macao Special Administrative Region pursuant to Article 31 of the Constitution of China. According to the policy of one country, two systems, and the basic law of the Macao Special Administrative Region, the Macao SAR enjoys high degree of autonomy and is directly under the central government of China. While the central government is responsible for its defense and related foreign affairs, the Macao SAR has its own executive, legislative powers, an independent judiciary, and the power of final adjudication. Experience over the past 13 years has demonstrated the success of the policy of one country, two systems, as it has promoted the development and prosperity of Macau and has gained the support from people of both Macau and mainland China. Pursuant to the basic law of Macao SAR, the relevant provisions of the International Convention on Civil and Political Rights, which are applicable to Macau, continue to be enforced after 20th December 1999 and are implemented through the law of the Macao SAR. At present, China is not a member state to the convention. However, in order to give full play to the principle of one country, two systems, and to ensure that your committee and the international community at large have a better understanding of the implementation of applicable provisions of the convention in the Macao SAR, the Chinese government transmitted in May 2011 the first report of Macao SAR, which was prepared independently by Macao SAR in accordance with applicable provisions of the convention. The Macao SAR attaches great importance to the review of its first report. A delegation headed by Ms. Florinda Chen has come to Geneva to attend your committee's review of the report. Madam Head of the delegation will give you a detailed presentation of the report and answer your questions during the review. I trust that you and members of the committee will give full support to Ms. Chen and her colleagues in their work. Thank you, Mr. Chairman.
Thank you.
Thank you.
Mr. Your Excellency, and we look forward to the constructive dialogue that we're going to have with the delegation.
Thank you.
Thank you.
I wish your consideration will be successful.
Thank you.
Thank you. Thank you.
好，谢谢，谢谢，可以来是吧？
Welcome, Ms. Chan. Very nice to meet you. And welcome to the committee. We look forward to the dialogue which will take place, the constructive dialogue that will take place with the delegation. And at this point, I invite you to make your introductory statement.
Thank you.
You have the floor, ma'am.
Thank you. Mr. Chairman, distinguished members, good afternoon. On behalf of the government of the Macao Special Administrative Region of the People's Republic of China, I am honored to address to your committee on the occasion of the first report of the Macao Special Administrative Region of the People's Republic of China regarding the implementation of the International Covenant on Civil and Political Rights. I wish, first of all, to thank Ambassador Liu Zhenmin, Permanent Representative of the People's Republic of China to the United Nations Office at Geneva, for making the necessary arrangements for our attendance and for his kind introductory remarks. Let me introduce the key members of our delegation. They are Ms. Zhu Lam, Director of the Law Reform and International Law Bureau, Deputy Head of the Macau SAR Delegation. Mr. Raimundo do Rosario, Director of the Macau Economic and Trade Office in Geneva. Mr. Yonggong Yu, Director of the Social Welfare Bureau. Mr. Zhu Lin, Ms. Jiang Wenkei, and Ms. Gu Meileng, Advisors to the Office of the Secretary for Administration and Justice. Ms. Hilda Cristina Ferreira, Mr. José Luciano de Oliveira, Advisors to the Office of the Secretary for Security. Ms. Deng Akan, Deputy Director of the Labor Affairs Bureau. Mr. Lai Kam-kun, Deputy Commissioner of the Public Security Police Force. Ms. Lam Pui Cheng, Chief of Department of the Government Information Bureau. Mr. Chairman, since the People's Republic of China resumed its sovereignty over Macau on December 20, 1999, Macau has become a special administrative region of the People's Republic of China with a high degree of autonomy, granting its modus vivendi and modus operandi allied to the self-governing powers of executive, legislative, and independent judicial powers, following the principle of one country, two systems abiding under the Basic Law of Macau. The Basic Law, having its constitutional value, was adopted by the National People's Congress of the PRC and entered into force on December 20, 1999. In accordance with its Article 138, international agreements to which China was not yet a party, but which were applicable to Macau, continued to be applied in the Macau SAR. The ability to maintain and develop relations and conclude agreements with foreign states and regions or international organizations in the appropriate fields using the name Macau China illustrates the Macau SAR sui generis legal status. The Macau SAR has an area of approximately 30 square kilometers with 582,000 inhabitants in the year 2012. Due to its history, which goes back to centuries ago, the region reflects its multi-ethnic diversity, where different communities live together in a harmonious society and where cultural, religious, and linguistic differences are respected and promoted. In 2005, the historic center of Macau was inscribed on the UNESCO World Heritage List, making it the 31st designated World Heritage Site in China. Mr. Chairman, I would like to take this occasion to outline some of the major initiatives and achievements that the Macau SAR government has been undertaking in relation to the implementation of the Covenant. The principle of one country, two systems has contributed to the enlargement of the scope of human rights in the Macau SAR in accordance with the Basic Law, with the adoption of relevant conventions on the field of human rights. The Macau SAR government is deeply committed with the effective implementation of the International Covenant on Civil and Political Rights. For the past 13 years, since the return of Macau to the People's Republic of China, our social development has been on a gradual and steady progress with the joint effort of the Macau population. The government policies stress on increasing significant resources to improve the welfare of the population, such as upgrading the Social Security Fund and access to education, including implementing a basic 15 years free education system and financial subsidies to local students, whilst improving medical care and benefits for the seniors, children, students, disabled and unprivileged groups, as well as setting up measures to alleviate inflation, creation of a food safety center and food bank, wealth sharing and public housing schemes. The Macao SAR government's policy fostering populations' greater understanding on the protection of human rights has been carried out through a proactive strategy consisting of human rights training and education, as well as public awareness campaigns in multiple languages, such as in Chinese, Portuguese, and in English. New legislation was enacted to comply with the obligations set forth in the ICCPR, and international instruments applicable to the Macao SAR on human rights and other rights have been reinforced, such as in the field of data protection, against drugs and human trafficking, labor relations, persons with disabilities, refugees, access to law and legal aid, protection of women and children. These measures have been adopted to provide adequate assistance to vulnerable persons, as well as to promote dialogue and cooperation with local NGOs in tackling relevant social issues. In respect of the monitoring and supervisory mechanisms on human rights, our judiciary bodies observe and consider whether Macao legal order is in conformity with international conventional law applicable to Macao SAR. Other institutional body within this context is the Ombudsman, which main function is to protect the rights, freedoms, safeguards and legitimate interests of the individuals and to ensure the legality in the exercise of public authority, justice and efficiency in the public administration. In addition, a growing number of institutions to promote, monitor and safeguard human rights has been established, the majority of which is composed of prominent individuals and representatives of the NGOs, such as the Commissions on the Protection of Victims of Violent Crimes, Refugees, Women's Affairs, Disciplinary Control of the Security Forces, the Combating Against AIDS, Mental Health, Senior Citizens Affairs, the Fight Against Drugs, the Deterrent Measures Against Human Trafficking, and on the Rehabilitation of Persons with Disabilities. The contribution of the NGOs, whose aim is to strive for a harmonious livelihood, should also be emphasized through their proactive participation. They set up hotlines, study the social problems and measures to counter them, promote public awareness of the existing legal system, and act as an intermediary between the government and the population. The Macao SAR government maintains regular dialogue with the NGOs and fully encourages the participation of residents in public affairs and political life through public consultations before major policies decision-making and law drafting. An important aspect in this regard is the Macao SAR political system development in 2012 with the amendment to the methodology for the constitution of the Legislative Council, the methodology for the selection of the Chief Executive of the Basic Law, and their corresponding local electoral laws. Such process was consistent with the Basic Law and the reality of Macao, where a gradual and smooth democratization process for its political system is being undertaken. It should be highlighted that this was a process open to the community, which received the full participation of Macao residents and local associations through public consultations. Mr. Chairman, facing both challenges and opportunities ahead, the Macao SAR government is aware of its responsibility to promote the knowledge of its people on the human rights international instruments applicable to Macao and respective local law in compliance with the Basic Law and the ICCPR. We shall take the necessary steps to promote civic education, human rights dissemination, legal training and education to the population and to government officials on a continuous basis. It is also worth mentioning that the government of the Macao SAR strives for a balance between promoting social and economic development and the challenges associated with such progress. The government continues to uphold the aim of a people-oriented principle in the administration, strengthening good governance, integrity, and participation in public affairs. Mr. Chairman, distinguished members, we are very grateful for this valuable occasion to reiterate our total commitment for the implementation of the covenant enshrined in our constitutional basic law. We appreciate this opportunity to exchange views with the Human Rights Committee and look forward to a constructive and fruitful dialogue. We shall do our best endeavor to respond to your queries. Mr. Chairman, with your permission, I would like to invite Ms. Chu Lam Lam, Deputy Head of the Macau Delegation, to highlight the Macau SAR response to some of the key questions in the list of issues identified by the committee in September 2012. Thank you very much, Mr. Chairman.
Thank you very much indeed, Ms. Chan, and I'm happy to give the floor now to Ms. Chu. You have the floor, ma'am.
尊敬的委员会主席及各位委员
Honorable Chairman, members of the committee, I'm very honored to be here to introduce to all of you the implementation situation of the International Covenant on Civil and Political Rights in the Macau SAR. I'm going to briefly elaborate on the questions raised by your committee in the list of issues and on certain major developments. Pursuant to Article 40 of the Basic Law, the provisions of the International Covenant on Civil and Political Rights, which are applicable to Macau, continue to be enforced and are implemented through the laws of Macau SAR. As mentioned in our reply to number 2 of the list of issues, international treaties are applicable to the Macau SAR by means of e-cooperation. Judicial organs can directly cite the relevant treaties as the legal basis for judgment. Furthermore, natural persons or legal persons can also directly evoke the aforementioned treaties for standing for their own rights and ascertaining relevant obligations. For instance, in case number 792/2010 Criminal Appeal of the Court of Second Instance, the suspects directly cited the clauses of the covenant to assert their own rights. After the handover, the rights and freedom of Macau SAR residents, including those who are Portuguese descendants, are safeguarded according to law. As regards to Committee's concern expressed in issue number 17. In fact, the rights of Chinese nationals of Macau who were originally holding Portuguese travel documents are not diminished after the handover and are entitled to the corresponding rights and freedoms of Macau SAR residents pursuant to the Basic Law and the relevant provisions. The committee was concerned about the issue of freedom of expression in Macau after the handover. It must be noted that the committee's concern or doubt does not exist. The Macau SAR upholds the freedom of press, speech, and publication, and the freedom of press and speech is adequately safeguarded. Among which Article 27 of the Basic Law grants Macau SAR residents the freedom of speech, press, and publication. On the other hand, it must also be pointed out that the media industry has continued to grow after the handover of the Macau SAR. In fact, the number of newspapers published in the Chinese language has increased from 8 to 10, with one of them being a newly published free newspaper. The number of newspapers published in Portuguese has increased from 2 to 3, while the 3 newspapers in English were founded after the handover. With regards to the broadcasting industry, 1 cable TV station and 3 satellite TV stations began services after the handover, bringing richer and more diverse information to the Macau citizens.
Apart from an increase in the number of media institutions, the local media institutions have also been constantly enhancing their role in monitoring the government in respect of law enforcement. In recent years, the newspapers and electronic media have been successfully issuing special columns or programs for commenting on current affairs and political issues, while the electronic media has also been launching programs related to current affairs and political issues, which involve direct interactions with residents. These initiatives demonstrate that the press and the residents continue to enjoy freedom of press and speech after the handover. The protection of the rights and benefits of women, minors, the elderly, and the disabled are not solely the concern of the committee, as expressed in issues numbers 18, 19, and 23. It is also the issue to which the Macao SAR pays great attention. With respect to legislation in order to promote family harmony and protect the minors, women, the disabled, and the elderly, who are probably in a comparatively fragile situation or condition, rather, the Macao SAR government is drafting a law on the prevention of domestic violence and the legal framework for the protection of the rights and interests of the elderly. The Macao SAR government pays great attention to a comprehensive care for the elderly. Hence, the elderly who are 65 years old are entitled to receive old age pension every month and elderly respect pension every year. In addition, the elderly may also apply to the Social Welfare Bureau for subsidies so as to ensure that their basic needs of life are satisfied. What is worth mentioning is that the Macao SAR government has planned to increase the old age pension and the elderly respect pension to MOP 3,000 per month and MOP 6,600 per year, respectively, in 2013, so as to make the level of protection for the elderly's retirement life higher than the minimum subsistence index, thus providing more protection for the elderly in terms of retirement life. Furthermore, disadvantaged families, including those with members with disabilities and chronic illnesses, may apply for treatment disability subsidies. With the financial and technical support of the Macao SAR government, certain NGOs provide residential facilities, home care services, and other community support services for those in need, including the fairly frail, elderly, vulnerable women, persons with disabilities who lack family care, and so forth. As regards the protection of the rights of the child, the Macao SAR government provides 15-year compulsory education or tuition subsidies for students enrolled in the non-tertiary education institutions of formal education so as to guarantee Macao SAR residents, including legal immigrants, their right to education in the economic aspect. The Macao SAR government prohibits all forms of corporal punishment on children. The execution of the act of corporal punishment on children, according to the circumstances of offences, is punishable pursuant to the different charges stated in the Macao Criminal Code. The student discipline system for government education institutes explicitly prohibits schools from adopting any penalty that harms students' mental or physical integrity and their personal dignity as a disciplinary penalty. The Education and Youth Affairs Bureau distributes the school operations manual that provides for the elimination of all forms of corporal punishment every year and established a notification system together with the campus crisis management teams. Should violations of the aforementioned guidance be found, the schools must notify the aforementioned bureau so that it can launch an investigation and impose penalties pursuant to law. Law number 2/2007 expressly prohibits the Youth Offenders Institute for adopting educational supervision measures that harm students' physical integrity, health, and dignity. For this reason, the Young Offenders Institute arranges a relevant pre-entry training program for its new staff and organizes regular internal trainings for other staff as well. As mentioned by the committee in number 22, number 24 of the list of issues, with respect to the protection of non-resident workers, the law of the Macao SAR protects non-resident workers from discrimination for working in the Macao SAR and guarantees their receipt of no less favorable treatment and protection compared to resident workers. Apart from Article 43 of the Basic Law, the Labour Relations Law stipulates that employees shall not be harmed or deprived of any right on the grounds of their nationality, race, descent, and so forth. Furthermore, the principle of non-discrimination established in the law on the employment of non-resident workers grants non-resident workers no less favorable treatment compared to resident workers in terms of rights, obligations, and working conditions. What is worth mentioning is that the Labour Affairs Bureau conducts routine patrols around work venues, and any situation of discrimination of local or non-resident workers will be prosecuted and penalized pursuant to law. Significantly, no complaint about discrimination has been reported to the Labour Affairs Bureau so far. As regards the issue of the implementation of the minimum wage, the Macao SAR government will continue to facilitate the tri-party of employees, employers and politicians to launch discussions about the establishment of a minimum wage system in coordination with the circumstances and needs of the development of our society. Before that, the government will adopt measures to relieve the economic pressure of low-income employees. Among the low-income employees, the outsourced security guards and cleaners of the Macao SAR government are already protected by the statutory minimum wage. In relation to the combat against crimes, for instance, the measures for combating terrorism concerned by the committee in number 4 of the list of issues, the Macau government established a Financial Intelligence Office in 2006 and signed a Memorandum of Understanding or Cooperation Agreements with 11 financial intelligence units, respectively, so as to consolidate the collection of intelligence and data from law enforcement organs in other regions and foreign countries. Moreover, the government adopted the laws regarding the fight against terrorism and the financing of terrorist activities in the light of international norm and joined the Asia-Pacific Group on money laundering in order to accept the APG's assessment of the Macau SAR on the latter's accomplishments in the fight against the financing of terrorism. The combat against terrorism does not affect the protection of human rights. Any person suspected or accused of committing terrorism or the financing of terrorism in the Macau SAR shall be entitled to criminal procedural guarantees, the right to appeal, habeas corpus, the right to compensation for illegal arrests, the right to equal, fair and public hearings, and so forth. In the aspect of preventing and penalizing sexual and economic exploitations, which is the committee's concern as expressed in number 15 of the list of issues, the Macau Criminal Code provides for criminal penalties for the relevant acts which can effectively combat and penalize acts of sexual exploitations, sexual slavery, and so forth of women, and prosecute the offenders who cause women to be stranded in the threat of sexual coercion. Furthermore, several labor relations laws also safeguard the principle of equal remuneration for equal work or comparable value in order to protect all employees from irrational exploitation. At the level of law enforcement, the Macau SAR has always been committed to the combat against all crimes, works closely with the police authorities of neighboring regions to exchange intelligence, establishes communication mechanisms, cooperates with the International Criminal Police Organization in the area of organized crime and the crime of trafficking in persons, and conducts sampling surveys with visitors, especially young women, arriving at border checkpoints in order to find out if they are being exploited of prostitution, threatened or persecuted. Concerning the protection for victims, the government provides funds and technical assistance for women's shelters and NGOs of related areas every year for them to provide shelters and consultation services to persons at risk and victims of violent crimes. In addition, the Judiciary Police, the Public Security Police and the Health Bureau have also set up 24-hour assistance hotlines for victims of violence. In order to effectively combat the crime of trafficking in persons and protect victims, which is the committee's concern as expressed in number 14 of the list of issues, the Macau SAR government has strengthened its efforts through measures and policies in 4 areas, including legal stipulations, measures to prevent and combat activities of trafficking in persons, protection and assistance for victims to reintegrate into society, and international or regional cooperation. Lastly, concerning the encouragement of the establishment of NGOs, as stated in the reply to number 1 of the list of issues, the Macau SAR is a region that enjoys freedom of association. The Macau SAR government encourages the establishment of NGOs, which, according to the law, can apply for government for assistance allowance The Macao SAR government encourages and supports NGOs with charitable, medical, educational or other charitable purposes such as tax exemptions, financial subsidies and so on and so forth. As of November 2012, there had been already 5,605 organizations that had previously registered at the Identification Bureau, which fully mirrored the existence of the right of association in the Macao SAR. Honourable Chairman and members of the committee, what was mentioned earlier is the latest progress of the Macao SAR in its implementation of the International Covenant on Civil and Political Rights, and we will continue to do our best in the enforcement of the covenant. My group members and I are very pleased to continue answering the questions raised by the committee. Thank you.
Thank you very much, Ms. Chu, and thank you both for so scrupulously respecting the time guidelines that we try to set for ourselves. We now come to the point where colleagues on the committee will put questions to the delegation. For the first round, there'll be 2 rounds. First round 1 to 13, second round 14 to 25. And so I now invite colleagues to put questions on issues 1 to 13. And the first speaker on my list is Mr. Kalin. You have the floor, sir.
Thank you, Chair. I would like to very warmly welcome the distinguished delegation of the Macao Special Administrative Region. In fact, it's a special pleasure to have you here and engage in a dialogue on your initial report as Special Administrative Region. Of course, Macao is no stranger to this committee, taking into account that the committee had the opportunity to examine Portugal's report relating to Macao in November 1991. The present report, in fact, was due in 2001, and I must say that we regret its late submission in 2011. However, we are looking forward to have this opportunity to re-establish more regular contacts with Macao SAR. And I, in particular, would like to thank for the report because it's very detailed. It's not only describing the law, but also contains important statistical data, and in that sense is an excellent basis for our discussions today, even though sometimes we would have wished to hear a little bit more about the challenges you are facing in implementing the covenant. I'm in charge of addressing issues number 1, 2, 3 and 13 on the list of issues. And in this context, I also would like to sincerely thank for the extensive replies provided to us in advance. To have such written replies greatly facilitates the preparation of the dialogue, and I was also thankful for the summary of these replies that was just presented to us. Issue number 1 referred to references to our previous concluding observations back in 1999, and we ask you to indicate to which extent the State Party implemented the committee's previous recommendations. In fact, I'm grateful for your replies because even though the report is entitled Initial Report, I am very happy to see your reaffirmation of the continuity of the application of the covenant to Macao SAR. And I also saw that, in fact, you did address many of the issues that were raised back in 1999, and we will address them when we are coming to those points in the list of issues that are relevant for follow-up. Turning to issue, so I don't have any question on issue number 1. Turning to issue number 2, where we are asking whether individuals have directly invoked provisions of the covenant before domestic courts, where we ask about data on complaints lodged from 2009 to date to the Commission Against Corruption, to the Public Information and Assistance Centre and the Labour Affairs Bureau. I would like to again thank for the written replies, but follow up on what you said. I have several questions and comments. First, in paragraph 2 of the reply to our list of issues and paragraph 34 of the initial report, and also today in the oral presentation, you say that international treaties are applicable to the Macao SAR by means of incorporation, and that provisions of the covenant can, to the extent that they do not need implementing legislation, that they can be directly invoked by individuals, directly applied by courts. You also mention in the report that in case of conflict between a law and the covenant prevails. First, I would like to better understand what incorporation means in this context. I've been looking at the declaration made by the government of the People's Republic of China in December 1999 regarding the Covenant on Civil and Political Rights. I'm referring to paragraph 4, where it says that the provisions of the Covenant which are applicable to the Macao Special Administrative Region shall be implemented through legislation. Could you further explain to what extent the Covenant is directly applicable, meaning where no implementing legislation is necessary, and which provisions of the Covenant you think do need implementing legislation, as referred to in your report, and whether such implementing legislation has in fact been enacted regarding those guarantees of the Covenant you are not considering to be directly applicable. Second issue, in paragraph 13 of the replies to our list of questions, you're referring to an interesting case, number 792/2010 of the Court of Second Instance, where the Court of Second Instance actually cited Article 14 of the Covenant. This was a criminal case regarding libel. I would not like to comment on the case as such, but rather on a sentence in your reply where you say that, and I quote, "In addition, the Criminal Procedure Code does not prohibit the dual identity of the criminal police and the liable victim, who is the director of the judiciary police in this case, from being involved in the criminal investigation of the related offence." The case was about, it was a libel case, and the victim of the libel was the director of the judiciary police. And the person who was accused here of libel claimed that the director of police was in fact involved or even did conduct the investigation against him. The court said, no, this was not the case, so I don't see a problem. But what you say here is that it would be okay if under the laws of the SAR, if the victim of a crime would be the one conducting the investigation, preparing the prosecution. Now, I would suggest that this would not really be in line with basic principles of fair trial. And so we might have, and again, I'm not commenting on the specific case, just theoretically, we might have a conflict between domestic law and the Covenant. So how does your answer here, that this is not a problem, comply with the principle you also stressed, that the covenant prevails over domestic laws? So that's another aspect of the position of the covenant in domestic law, and we really would like to understand more about it. Third point here, of course, the possibility for individuals to directly invoke the covenant is limited by reservations that were declared in 1999. That's the nature of reservations. What I would be interested in is whether there has been, or whether you are plan, or whether there are any plans to assess whether these reservations are still necessary, or whether at least some of them could be withdrawn at this time. Of course, we'll come back to the issue later regarding reservations to Article 25, but I'm particularly now interested on the reservations regarding Articles 12 and 13. Moving on to issue number 3. Here we ask whether the State Party intend to establish a national human rights institution in accordance with the Paris Principles. You are certainly right to highlight in your reply that a national human rights institution cannot be the topic of our dialogue. What in fact we meant was something different. What we in fact wanted to address is the follow-up to paragraph 8 of our 1999 concluding observation. There we recommended the establishment of an independent statutory human rights commission for Macao, SAR, not the national Chinese human rights institution, but one for Macao. And you respond to that by saying that you do have sufficient institutions to protect of the rights of the citizens. Still, I would like to hear your comments more specifically on this previous recommendation to establish an independent statutory Human Rights Commission for Macao, SAR. The reason why I'm asking this is the following. You say that the mandate of the Commission Against Corruption and the Ombudsman of the Commission Against Corruption has been expanded to cover many areas of human rights. I would like to better understand whether the Commission Against Corruption could really cover the whole covenant on civil and political rights. I would like to know, in this regard, what kind of activities did the Ombudsman and the Commission undertake? Did they, in fact, undertake investigations not related to corruption, but to other aspects of human rights? I do see a clear link between the corruption issue and the human rights issue, but it's only one aspect of human rights. How many such investigations relating to aspects of human rights not linked to corruption have been undertaken? What were the results? And then also, to what extent is the Commission and the Ombudsman, to what extent are they independent? I understand that they are directly responsible to the Chief Executive. Is this independence in the sense of the Paris Principles? So if you could provide us with information and your views on these issues, this would be very important. Also, with regard to this issue number 3, in both the replies but also now the oral presentations, you refer to the many commissions that do exist, commissions on different issues that also have as members non-governmental organizations. And again, certainly they do important work. But from the perspective of the question of an independent human rights institution for Macau, I wonder to what extent we really can talk about independence here. It was reported to us that the NGOs are heavily dependent on governmental funding, that some of them, and that's an allegation, I cannot examine it, assess it, but I would like to have your comments, that some of these NGOs are more kind of de facto political parties than really NGOs defending and protecting human rights. Again, your comments would be very much welcome. Turning to the last issue, I'm going to address issue number 13. There we said that in our previous concluding observations we expressed concerns that no firm agreement has been reached on the transfer of Macau residents to face trial in other jurisdictions in China, or on their extradition to other countries in cases where they might face heavier penalties than laid down in your own penal code, including the death penalty. And we ask you for updated information. And in fact, such updated information was provided, so thanks again. And I really would like to welcome the information you provided on law number 6 on the judicial cooperation in criminal matters. That clearly sets out the transfer of Macau SAR residents to countries other than the People's Republic of China, where they would face the death penalty, ill treatment, or perpetual or indefinite deprivation of liberty. And I'm also happy to see that the law is in fact applied. You mentioned one important case where extradition was refused because the country concerned did not give assurances that the death penalty would not be imposed and not be executed. What I do not really understand is your answer regarding transfers from Macau SAR to mainland China. You mentioned one case where such transfer was stopped by a court with the argument that there is no legal basis for such transfers. Does this mean that no transfers at all are taking place to mainland China? If they are taking place, and I suspect or assume that they are taking place because it would be a normal thing to cooperate on criminal matters in a situation like yours, would it mean that offenders could be transferred even if they would face the death penalty? And if yes, how would this be compatible with the covenant? Of course, the covenant does not prohibit the death penalty, but as you know, it is the position of this committee that if a country has abolished the death penalty, then it can no longer extradite to countries that are still having and using the death penalty. And here we're getting back to the issue of continuity, because Portugal had abolished the death penalty. So from our perspective, transfer to mainland China in death penalty cases would not be compatible with the covenant. Again, I would be most grateful for your comments and explanations, and I'm looking forward to them. Thank you very much.
Thank you very much, Mr. Kalin. Et maintenant, je donne la parole à...
I now give the floor to Ms. Mottock. Ms. Mottock, you have the floor.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chairman. I would also like to congratulate the delegation of Macau SAR for their presentation of the report, as well as the replies they have provided. Although, of course, this has been quite late, as my colleague said, as regards the supposed date of submission. My first question relates to question 4 and the measures that you have taken with Law 3/2006 on the prevention and suppression of the crimes of terrorism. Now, like in all cases where laws of this nature are adopted, the problem to our mind is whether these laws, which have been adopted to prevent and suppress crimes of terrorism, whether in fact they affect human rights. So by implementing these measures, are human rights then violated? And you have indicated in your replies on page 42 that entry can be refused to non-residents of Macau when it is considered that they are suspects of the crime of terrorism. So I'd really like to know how these laws are applied. Do they only affect suspects of terrorism with well-founded proof who are then stopped at the borders? Or have you seen cases with people who have been refused entry as being suspected of having committed the crime of terrorism? So I also wanted to ask you something which is important as regards terrorism, namely the issue of deportation and expulsion. As you have clearly said in your written replies, these expulsions do not affect Macau citizens but may affect foreign residents, foreign citizens, particularly when they are suspected of having committed crimes of terrorism. And this is of concern to me because I'd like to know whether there are other people other than people who are suspected of having committed crimes of terrorism, if other people are deported from Macau under that pretext. And what are the guarantees offered by this law to people suspected of terrorism as regards entry and as regards deportation? My second question relates to question 6 on Article 4 of our Covenant regarding the state of exception and as state of emergency. And as you know, this law on states of emergency must, in reality, suspend certain rights, but cannot suspend all rights, because they're rights that are non-derogable, even if there is a state of emergency in force. So we'd like to know whether this law on security, which you've adopted in 2002, Law 9/2002 on internal security, whether that offers guarantees as regards non-derogable rights during states of emergency. As we know from your replies, but also from the information that we have received, it would appear that problems that we're concerned about affect laws as regards the protection of national security and all these domestic laws regarding security. And as you know, there are reports from non-governmental organisations regarding the balance struck between those rights, between protecting human rights and potential abuse which may be committed because of this need to protect security. So I'd really like to know what rights are considered to be non-derogable during states of emergency, particularly with regard to this Law 9/2002. Now I have another question which I believe is very important regarding the issue of persons victims of sexual violation and people victims of sexual exploitation. In our previous concluding observations, we had mentioned that this is a problem in your country, and so we'd like to know what measures you have taken. Do you have any statistics regarding women victims of sexual exploitation and children who may be victims of sexual exploitation? Because the two reports, report from CEDAW and from the Commission on the Rights of the Child as regards Macau, both mentioned this issue of sexual exploitation. Do you now have statistics as regards the number of persons who have been victims of sexual exploitation? And do you have information on specific cases? Have you carried out investigations to look at these networks, to see how people end up being victims of these networks, in particular in your country? I'd like to know whether the immigration policies as regards sexual exploitation in a country like Macau, which obviously is a concern for you, these networks, people involved in these networks. Do you have information as regards the fact that women are often victims of sexual exploitation to pay their debt? Because there's are there measures linked to that issue? Now, I'd like to come back to criminalisation, and I'd like to know if you can give us any indications as regards combating crime, the fact that you can try somebody twice for the same crime and you can then apply this retroactively. Thank you very much, Chairman.
Thank you, Madame. Merci, Madame.
Thank you, Ms. Motok.
Just reassure the delegation now that it doesn't need to respond to issues beyond 1 to 13 at this stage. The next speaker on my list is Mr. Flinterman. You have the floor, sir.
Thank you, Mr. Chairman. Well, first of all, I would like to join my colleagues in welcoming most warmly the delegation of Macao SAR to Geneva and to our committee. I would like to express also my deep appreciation for the very informative core document that you submitted, because that helps us in understanding the overall legal, political, social and economic infrastructure of the country concerned. And also your initial report was a rich source of information. I was very pleased further with the very detailed information that you provided in reply to our list of issues, as briefly summarized today in the opening statement of your delegation. I have a further query first under issue number 5. Under issue number 5, the committee requested you to give some more detailed information on the substance of that very interesting law of 2002, number 9, 2002, which requires the police to seek the authorization of the judiciary in order to have access to correspondence, computer databases, and other private information. That indeed is a far-reaching power of the police, and it's quite, I think, important that that power has been made dependent upon a previous judicial authorization. In your replies, you informed the committee, Madam Head of Delegation, that that particular article of the law of 2002, law number 9 of 2002, so far has never been used. So it is maybe to some extent an academic question, but I will come back to it in a moment, because I very much appreciated also the effort you made to indicate that this power of the police, if used, if ever used, would be balanced against the law on protection of personal data and private life, that is law number 8 of 2005. In order, Madam Head of Delegation, to be fully satisfied that the measures under law number 9 of 2002 are fully in compliance with the requirements of the Covenant on Civil and Political Rights, I would like to ask you to give us further information or to detail the information on the legal safeguards that are in place for persons that could be made subject to monitoring of their communications as prescribed in the law number 9 of 2002. and further to clarify whether persons concerned are informed of such measures and whether in such situations they have the right to appeal against the decision by a judge to authorize such measures. And once again, I realize, Madam Head of Delegation, that it is so far an academic question because you have informed us that the particular article has not been used so far. But my question is, when it will be used, are those safeguards in place? And my second question relates to issue number 10, where once again the committee has requested the government of Macao, SAR, to give some more information on a particular very interesting law number 2 of 2007 on the juvenile justice system. And that particular law is called the Law on the Educational Supervisory Regime for Youth Offenders. I was particularly pleased to read paragraph 67 of your replies to the list of issues. And maybe you allow me to quote it, where you indicate to us that under the new legal regime, judges have more pluralistic measures to opt when judging youth offenders, which can help the youth offenders to turn over a new leaf in a more efficacious manner. And furthermore, the judges must always adopt a measure of non-deprivation of liberty prior to the measures of deprivation, with the confinement being the last resort of the measure of deprivation of liberty. End of quote. And my question here, Madam Head of Delegation, is a question about the application of this law of 2007 in practice, whether it would be possible for your delegation to enlighten the committee about, well, first of all, the size of the problem. How many youth offenders do you have in Macao, SAR? How many of them are deprived of their liberty as a result of a judicial decision? And what other measures have been in practice imposed? And you refer to very interesting, I think, very relevant measures such as police cautioning measures, community service orders, and restorative justice measures. So this question is about the application of the law of 2007. And, Madam Head of Delegation, I'm looking forward to your replies. Thank you very much, Mr. Chairman.
Thank you very much, Mr. Flinterman. Et maintenant, je donne la parole.
I'd now like to give the floor to the next speaker. Mr. Benachir, you have the floor.
Merci, Monsieur le Président.
Thank you, Chair. I would, following on from Mr. Kellin, I'd like to extend a warm welcome to the delegation from Macau and also congratulate them on the answers that they have provided to the questions, the list of issues. Generally speaking, these are fairly precise answers, and they seem fairly sufficient as regards the information contained. I'd like to start with a question. Question 6 has to do with equal treatment, particularly as regards equal pay for women and men in certain areas. Now, the answer you provided to that question covers a part which has to do with the legislation, and the rest really has to do with facts and figures on the law. The answers provided do seem appropriate because you do say in your answers that there are many laws and decree laws which ensure equal opportunities, treatment and pay between men and women. You mentioned Decree Law 5295M on equal opportunities and treatment for employees, men and women employees in their labour relations. You also mentioned 498M as a law, particularly Article 5 thereof. And you also mention 7 2008, which is the Labour Relations Law, and more particularly Article 57, paragraph 2 of that law. If we look at all these legal provisions as a whole, then it seems that the principle governing Macao's legislation is basically equal pay for equal work, be it for men or women. So, as I understand it, there is a general prohibition of discrimination regarding pay for men and women. You also added that the government applies the 1951 ILO Convention. This is number 100. And in addition to that, you have an advisory committee for women's affairs, or a consultative commission. And you also have, in English, the Labour Affairs Bureau, which disseminates and monitors equal opportunities and decides on any disputes. So in terms of the law, it seems that your legislation is all well and good. You also go on to give us figures and facts. In particular, in paragraph 39 of your answers, again, answers to question 6, in paragraph 39, you say that statistical figures show that the employment of women in Macau is not low, in the public sector in particular, but you go on to say that there are still gaps in the remuneration between men and women employees in the private sector. So in the public sector, it seems that things are satisfactory. However, in the private sector, you say that there are some gaps in pay. You recognize that yourself between men and women employees. So that is your answer. And in the light of that, I'd like to raise some questions on these answers you've provided. First of all, could you give us an idea of the share of female employment and male employment in the different labour sectors? By that, I mean in the health sector, for instance, in the world of academia, universities, in the justice sector, the police sector, etc. Is it possible for you to give us a more precise idea on the proportion of women and men employed in those different sectors? That's my first question. Secondly, the statistics you mention in paragraph 39. You mention statistical figures, but you don't actually provide us with any figures as such. Could we therefore have tables? I mean, similar to what you have in para 54. This has absolutely nothing to do with the point in hand, but you provide us with a table on rapes and sexual coercion, domestic violence. There, you provide us with quantified statistics. Would it be possible to have such precise statistics with tables, but relating to male and female employment? That's my second question. My third question. You recognize that there is a gap between men and women employees in the private sector. Could you be a little bit more specific? In other words, what order of magnitude are we talking about here? What's the size of the gap? And why? Why is it that in the private sector there does seem to be this gap between pay for women and pay for men? My fourth question. You say that a possible cause is that women simply prefer to stay at home and be housewives. And perhaps be prepared to take a home lower pay when they do work. And in that case, I'd like to ask the following. In some states, this choice, in other words, women prefer to stay at home to look after their family, is compensated by the state. The shortfall is compensated by the state. And my question is as follows, therefore. Does the government in Macau envisage adopting legislation that would compensate this shortfall, that some women deliberately choose to stay at home, that loss of pay would be compensated? And a final question relating to question 6. You mentioned the work done by the Labour Affairs Bureau, or is it the Women's Affairs Bureau? This bureau has a clear role, and my question relating to it would be as follows. In paragraph 14 of your answers, you say, however, this bureau, the Labour Affairs Bureau, has not yet received any complaint, and this between January 2009 and 30th of November 2012. That means that nobody's really calling on this bureau. I mean, there's no complaint that has come in. If so, there doesn't seem that there is any demand going in. There seems to me to be a little bit of a gap, I think, between what you say as regards the work done by this bureau and the lack of complaints that seem to be coming into this bureau. Those are my questions regarding 6. Let me now move on to another equally important question, and this has to do with the answers to question 8. In other words, combating rape and violence in the household, as well as sexual harassment in the place of work. This is 8, question 8. Now, you've given us, broadly speaking, a satisfactory answer. I would summarize your answer. First of all, you take a clear stance on the first question on rape. Secondly, as regards domestic violence, you provide us with plenty of information, and also on sexual harassment. So I'd like to make my comments specific to each and every of these questions. On rape, you give us a very detailed description of your legislation, of the criminal code in Macau. You say that rape is a crime, punishable under the criminal code, and the penalty or the sentence can go from 3 to 12 years of imprisonment. In addition to that, there are aggravating circumstances when it is part of family members within in the family. That is an aggravating circumstance committed by what is known as a descendant or descendant. Measures are taken by some public services here. In particular, the Legal Affairs Bureau is responsible for disseminating the law and raising awareness within schools. The Legal Affairs Bureau plays this role of disseminating knowledge of the law and issues relating to rape. Then you have the Health Bureau also involved. The Health Bureau is responsible for carrying out some investigations. And you also go on to talk about the role played by the Social Welfare Bureau, which has the task of providing assistance to minors who are victims of rape. And you provide us statistics on these problems set out in paragraph 54. So there is very little to add in that regard. Domestic violence. There again, you've given us a clear understanding of your legislation. You say that Article 146, Para 2 of the Criminal Code punishes going from 1 to 5 years of imprisonment domestic violence. Again, there are possibilities of aggravating circumstances. Again, if it has to involve family members, ascendant, descendant, that's an aggravating circumstance which is quite logical and normal. The question that I would ask regarding domestic violence is the following. You tell us that there is a law that is being studied at the moment on domestic violence. Could you tell us exactly where you stand as regards the drafting of this law? We've been told that there is a specific law for the problem of domestic violence. As I understand it, this has been studied for some months or maybe years. So could you give us a little bit of information as where you stand with this law? Is it soon going to be coming to fruition? Is it soon going to become law? Or are you still at the stage of studying this law? In the statistics that you provide us with, again, they're very interesting. Your statistics under Para 54 relate to rape, sexual coercion, domestic violence. When it's the woman who is the victim, domestic violence, when it's the man who is the victim, and when children are victims. What I noted from these statistics is that there seems to be a drop in cases of domestic violence. Between 2008 and 2012, there is a drop in domestic violence as regards women. We go from 239 to 165 cases in 2012. And where men are victims, not much of a change, just one, 18 to 17. However, I have to say I was really struck by the drop as regards domestic violence against children, going from 28 cases in 2008 to just one case in 2012. So really quite an enormous difference here. And the question I would ask you is this very marked reduction in domestic violence as regards children in particular. Do you believe this is due to specific measures that your government has been taking in order to protect children? Or do you think it's due to something else? As in your opinion, what is the reason underlying this drop in domestic violence against children? The third table has to do with sexual harassment or sexual coercion. I think that, as I understand it, you have no law as such in Macau on sexual harassment. Contrary to what the committee asked for in its not the Human Rights Committee, I should say, it's the committee, the CEDAW committee, had invited Macau to think about adopting legislation on sexual harassment. Apparently this doesn't exist yet, and my question therefore is, do you as a government intend to adopt a specific law on sexual harassment? And in a similar vein, do you have statistics on these cases of sexual harassment? And I conclude now with my final question. Question 11 on solitary confinement and discipline in your penitentiaries and the compatibility of these disciplinary measures with the rights protected under the Covenant. Again, the answers from your government are, generally speaking, satisfactory, and particularly as regards minors. You've given us some very precise answers on minors, legislation pertaining to them. You say that Law 2, 2007 protects those minors between 12 and 16, and that isolation, solitary confinement, is an exceptional measure, and it is never absolute, because for minors it is only for one night in the cell, in other words, in an individual cell. You don't use it for minors. It is only applicable at night. So your criminal code is very clement. It seems merciful in that regard, trying to protect minors. For adults, you've given us a precise answer as well. You say that this is governed by Decree Law 40/94/M, and that the Decree Law states that isolation as a disciplinary measure or solitary confinement is an exceptional measure. It cannot go beyond 1 month. In other words, the maximum period of solitary confinement is 1 month, and that the victim is informed in writing. And fourthly, you say that there is a possibility of appeal as well. So the detainees who are subject to disciplinary measures can appeal to both the judicial and administrative authorities and even take it to the Commission Against Corruption or indeed your legislative assembly. My question, therefore, on 11 is as follows. Whilst thanking you, of course, for your very comprehensive answers, as regards your prison population in Macau, I'd like to have an idea of what your prison population is, first of all, and then could you give it according to tranche of age? In other words, the categories of age, the age brackets of your detainees in your prisons. And could you also give us figures on your disciplinary measures? I mean, you've mentioned here solitary confinement, which is extreme measures, but of course there are other disciplinary measures that can be taken. Could you give us an idea of what the situation is as regards your prisons, but more specifically other disciplinary measures that can be taken? My final question, question 12, the use of languages in the courts. The official languages in the courts. This is an important question. Macau is a special administrative region in China using both languages on equal footing, both Chinese and Portuguese. In fact, you mentioned Article 2 of Decree Law 101/99M, which states that draft laws need to be drafted in either of these official languages with a translation to the other. So all laws have to be drafted either in Chinese and Portuguese, and either way, you imagine they're translated in Portuguese, they'll be translated into Chinese, and vice versa. That's what I understood, at least. So before going to your legislative assembly, they need to be translated into both languages. The same goes for court proceedings. In the courts, the evidence, the arguments, etc., everything used in court during litigation has to be translated. If there is a difference in languages between either party, for instance, then everything has to be translated or interpreted. The question I would ask, therefore, is as follows. Whilst congratulating you on your answer on languages, on the official languages in the courts, and with a view to drafting your laws, I just wanted to broaden this question a little bit, because the issue of languages in court and in drafting the laws also depends on a more general question on the use of languages in Macau. I'd therefore like to know whether residents in Macau, are they truly all bilingual in Macau? And in the situation of assumed bilingualism, as generations change, as time passes, is there a language that is losing ground, another that is gaining ground, and perhaps one language that is becoming less widespread in Macau and the other which seems to be taking over a little? Which language is winning the day, as it were? Do you see this phenomenon in your country? And I ask you this because it is linked to how you use your official languages in court and elsewhere. If you have true equality of languages in your society in Macau, then bilingualism will be properly respected in judicial proceedings, etc. If, on the contrary, we're seeing that one language is becoming stronger, then I think this gap will be felt when it comes to how these languages are used in court. So, Chair, these are my questions for the delegation, and thank you again for the very precise answers you have provided. Thank you.
Et merci à vous, Monsieur Benachou.
Thank you, Mr. Benachou.
The floor to Mr. Shani. You have the floor, sir.
Thank you, sir. I will try to be rather brief because Mr. Benashur covered a number of the points that I wanted to raise. Very briefly, then, on points 8 and 11, I would like to voice my concern about having no legislation with respect to sexual harassment. I believe that the answer provided in paragraph 60 of the responses of the Macao SAR to the list of issues is not fully satisfactory, in the sense that it notes that there are some cases in which sexual harassment would qualify as a lesser offense, such as treating an employee not with respect or in an impolite manner, which is clearly not an adequate response to sexual harassment. And in extreme cases, there would be either rape or sex coercion indictment, but it seems for the very mass number of cases of sexual harassment, there is no adequate response. And it is regrettable that, despite the fact that the CEDAW committee and also the ILO committee of experts have noted this, that the government has not taken measures to address this serious problem. With respect to number 11, I also want to congratulate the delegation for some of the clarifications with respect to solitary confinement of juveniles, especially the notion of that the confinement would only be confined to nighttime, and that the practice is that confinement does not exceed 7 days or 7 nights in this case. However, the fact that the law on the books still allows for 1 month of solitary confinement, even under these conditions, is a very harsh response. It has also been criticized by the Committee Against Torture. And I think that the delegation or the party in this case should do well to consider whether to revise this specific piece of legislation. Now, with respect to issue number 12, I am grateful for the delegation for the information on the number of judges in Macau. The question is, I would appreciate the delegation's views on whether this number is perceived as adequate in light of the growing case law and the growing caseload. The numbers that I have seen is that you have 28 judges for first instance at the first instance court, which have to handle something in the neighborhood of 25,000 cases a year, and that as a result, about half of the cases are not being processed on an annual basis. And the question is, what does the government do in order to address this growing backlog, which of course pertains to important rights under the covenant? Thank you.
Thank you, Mr. Shani. And I now give the floor to Ms. Seibert-Faure. You have the floor, ma'am.
Thank you, Mr. Chair. I would also like to extend my warm welcome to this distinguished delegation, and I would also express my appreciation for the responses to our list of issues. I would like to follow up on the relationship of the HRCtte to domestic law, and especially the basic law. And I would like to seek clarification on the meaning and the effects of the statements by the government of China of the 3rd of December of 1999, which was notified to the Secretary General with respect to the HRCtte and its application. I would first like to recall our general comment number 24 on reservations, which states that it's not always easy to distinguish between interpretations and reservations. In any case, I think that reservations have to be precise enough in order to determine the scope of the obligations undertaken by a state party. Also, I think it's essential not to make the application of the HRCtte dependent on domestic law. This is also a principle which is enshrined in the Vienna Convention on the Law of Treaties, which stipulates that states parties to a treaty may not use domestic law as an excuse for not complying with the treaty. So my question is, what are the effects of these statements? Does the statement purport to exclude or modify the legal effects of the HRCtte in its application to the state? I would like to turn to the statement made because I would like to seek clarification on the meaning. The first statement is that the application of the covenant to the administrative region shall not affect the status of Macao. I ask myself, what is the need of this statement? Does it go beyond the regulation of Article 1 ICCPR? Second, the provisions of the ICCPR, it is stated, shall be implemented in Macao through legislation of the special administration. Again, what is the meaning of this statement? Does it mean that only legislation may be the right way of implementation? Does it restrict the implementation? In that case, we would face some obstacles with respect to Article 2, which clearly states that legislation is only one means of implementing the ICCPR. And finally, the notification states that Macao residents shall not be restricted in their rights unless otherwise provided for by law. Isn't this does this purport to repeat the stipulations of the ICCPR? If yes, do we have a need? I ask myself whether this isn't in line with the ICCPR already, and whether we need such notifications in the first hand. I understand that this question has not been posed in the list of issues, and therefore I do not expect right away an answer from your delegation, but I would very much appreciate if you could follow up on that either tomorrow or in writing. Thank you very much.
Thank you, Ms. Seibert-Foer. I now give the floor to Ms. Waterfall. You have the floor, ma'am.
Thank you, Mr. Chair. Let me also join my colleagues in warmly welcoming this distinguished delegation. I have a very small question, actually, and my question is related to the domestic violence and other related violence. I also noted the fall in the cases in with regard to domestic violence. My question is, are there programs for the perpetrators of these kinds of violence for their to change their attitude and conduct in relation to violence? Because it's one thing to punish them, but the other thing is to have them for a better conduct in society. Thank you, Mr. Chair.
And thank you, Ms. Waterfall. Et maintenant, la dernière orateur.
The last speaker on my list, then, is Ms. Chanet. I give the floor, Madame.
Merci, Monsieur le Président.
Thank you, Chairman. I'd also like to welcome, as colleagues have done before me, the delegation from Macau. I'd like to thank them for their explanations, and I found the report to be well drafted and the responses to the list of issues and the summary to be very good. And the summary isn't always wonderful for our work, so I'm pleased to see that this one was. Now, I know that this question isn't on the list of issues, but I see in the basic law in Macau that there is a provision which seems to be slightly similar, not fully, but slightly similar to the basic law of Hong Kong as regards interpretation of the law. Article 143, it says that the power of interpretation of the law is given to the National Congress, so it's a body in Beijing. And it's that body which authorizes the courts to interpret the law. So this the system is decentralized or delegated, handed down by a body which doesn't apply the covenant. So my first question is as regards this issue. On the Macau courts, when there is, and this is something a little vague, when the central government has to request that the central government interpret judicial issues, the courts are then bound by that response, what the central body says. So I'd like to know if there are cases where this procedure is applicable, and if so, if you could give us examples of cases where courts have had to ask this question of the central body and whether this has affected fundamental rights guaranteed by our covenant. Thank you very much, Chairman.
Merci à vous, Madame.
Thank you, Madame Chani.
Okay, we have come to the end of the first round of questions from colleagues. This is the point at which we give the delegation a little pause to consult amongst itself to decide how to dispose of the questions. We'll have a 10-minute break, which means not more than 15.
Only 10? There are too many questions.
As soon as you can.
Okay.
And we look forward to the delegation's answers to the questions when it's able to come back. And just to recall that it's up to the delegation as to whether one person responds or several respond. It's you as head of delegation will decide whether, who is going to respond to the issues.
Thank you.
Thank you very much. Then, thank you, colleagues.